welcome to Arbitral Insights, a podcast series brought to you by our international arbitration practice lawyers here at Reed Smith. I'm Jose Estigarraga, Global Head of Reed Smith's International Arbitration Practice. I hope you enjoy the industry commentary, insights, and anecdotes we share with you in the course of this series, wherever in the world you are. If you have any questions about any of the topics discussed, please do contact our speakers. And with that, let's get started. Hello, everyone. Welcome to Arbitral Insights, Reed Smith's podcast series on international arbitration. I'm Jose Estigarraga, the Global Chair of Reed Smith's International Arbitration Practice, and I'm delighted to welcome a very special guest to our program, Alexis Mourre, the President of the ICC. For those of you just joining us, this is part 2 of our interview with Alexis. We've already broadcast part 1. We hope you will have the opportunity to listen to that one if you haven't. It was very, very interesting and insightful. As I explained in part 1, we thought it would be very valuable and interesting to ask Alexis to reflect on his presidency and to have an opportunity to ask him about the changes and innovations he led, and as well to ask him about his vision for the future. Alexis, welcome back to the program. I know our listeners are eager to hear more, so with that, let me get right to it. You led the ICC, of course, to expand its offices abroad. Do you believe that the ICC needs to have other offices in some other region? I'm not talking about long term, talking about in the short to medium term. Would you encourage the ICC to open any other regional offices?
That decision will not be made by me, of course. It will be made by my successor and the future vice presidents of the court. We have, under my presidency, we have opened new case management offices, as you know, in Singapore, Sao Paulo, and more recently in Abu Dhabi. Abu Dhabi started operations just some days ago. Whether there will be need for more, China certainly will be a question. There is an interesting evolution in China at the moment where we can see the cities of Beijing and Shanghai opening themselves to non-Chinese institutions to come to administer cases on the mainland. That's an interesting evolution. We will need to see whether the regulatory framework nationally adjusts to that, which is unknown. Of course, any institution like the ICC would need to be assured that China would be respectful of their independence and also of fundamental principles of due process and the right of advocates to exercise their duties. That's perhaps a question now for the future, but yes, China will be a question that institutions will need to look at very, very carefully.
Okay, makes sense. Alexis, let me ask you, is there anything that you wanted to accomplish during your term at the ICC that you didn't get to finish as you reflect?
Yeah, well, there is, I mentioned transparency and the publication of awards. I think we have introduced a very, very interesting and bold new policy there by providing for the transparency and the systematic publication of arbitral awards on opt-out basis. So far, the data I have is that we have lots of opt-outs. In fact, we're due to start publishing awards on the 1st of April for awards made from the 1st of January until the 1st of April 2019. And we've not been able to publish any either because of the presence of confidentiality agreements or of opt-outs, which can be explained away because these awards were made from January to April of 2019. Remember that our policy applies 2 years after when the award is made. So these awards were made in cases which were started before the policy was announced, so which may explain the high level of opt-outs, which came in, by the way, at a very late stage. I hope that the policy will be more accepted in the months to come, but certainly this is something that remains a work in progress, and I hope that it will continue. It's a long-term project. I mean, this is something on which not only the next president of the court, but also Claudia's successor in 3 or 6 years from now, and perhaps the future successor of her successor will need to work as well. This is something that needs to be seen at an horizon of 20 years. So perhaps another thing is, which is not a regret, but which is something which I would like to have seen evolving more quickly is the expedited rules. The expedited rules have been a tremendous success. We have decided to increase the threshold for the opt-out application of the expedited rules from 2 to 3. My proposal was higher than that in the discussion, which led to the adoption of the 2021 rules. I would have liked to see a threshold of 4 or more than 4. But of course, as always in politics, you need to make compromises. And we heard different parts of the constituency, and we decided to move to adopt a more gradual approach and increase the threshold from 2 to 3. But again, this is something that I really see as the golden tool of the arbitration of tomorrow, in the sense that, remember that on the 1,500 or so cases that are pending under the ICC rules, about 40 involve amount in dispute of less than 4 million. So, the expedited rules have proved to be extremely effective. We have made so far about 100 awards under the expedited rules, all save very limited exceptions made within the 6 months time limit, with a reduced scale of fees, with more limited representation cost for the parties, awards which quality is as good as that of any other award, which are scrutinized by the court with the same level of quality, albeit in a shorter time frame. So it is really a fantastic tool, and I hope that we will see it applied to a much broader range of cases in the future.
You bet. Interesting, Alexis. One question is, what was the biggest surprise that you encountered during the course of your tenure? As you began your presidency, you looked ahead, and now you reflect back. What was the thing that most surprised you about the undertaking?
I would say the ability in which the system has been able to adjust to COVID. COVID has had a tremendous impact. It came very brutally, and arbitration in general, not only the ICC, has been able to adjust to that in a very reactive and adaptable way, which has been to a certain extent a surprise. Of course, there are cases in which parties have been reluctant to move to online hearings, but I would say that overall the system has adjusted in a fantastic way. And COVID, now that we have more than 1 year of experience of the pandemic, we do not see, as you see in many judicial systems around the world, this has not resulted in a backlog of cases, of delays, of cases accumulating. Cases, arbitrations have been resolved, have been timely resolved. The system has adjusted, and that has been a very good surprise.
Interesting. Alexis, let me ask you, if that was the biggest surprise, if you would, what was the biggest challenge that you faced during your presidency?
Well, I think one challenge has perhaps been to get all parts of the constituency to accept fully that arbitration is also a service industry. Of course, not only that, but it's also a service industry. And when we have introduced the expedited rules in the 2017 ICC rules, so that has been done in 2016, I've been surprised by the level of skepticism and at times resistance that this has provoked. I had expected, of course, some level of opposition, but the debate at the time has been much harsher than I would have expected. But again, I think we've been fully vindicated on this by the way in which the system has worked so far. Equally, when we have introduced that rule, which you know about the three months to submit draft awards to the court for 3 members tribunals, it's 2 months for sole arbitrators, and the consequences in case of an unjustified delay in terms of fees reduction. Initially, there has been quite a lot of negative reaction to this amongst the community. Now it has been accepted. It has been accepted, I think, quite widely, exactly in the same fashion that when the ICC introduced the statement of availability for arbitrators, initially there was a lot of resistance, and then it was accepted. So it's on the one hand, it's a word which adapts very well, very easily, which is very flexible, but you still see those elements of resistance and conservation in some instances, which to some extent have been a surprise to me as well.
Let me ask you, Alexis, of course, you've been a driver of diversity at the ICC and otherwise. My question then is, as you talk about sort of, I'll call it inertia within the system where, sort of resist change. Do you think that as a result of the increase in diversity that you in concept or in practice would see less resistance and in fact more openness to change as, perhaps the new members of the arbitral community and institutions and so on aren't perhaps, as this is my speculation, as entrenched in the this is how we have always done it mode of thinking?
Oh yeah, I'm completely convinced of that. I mean, the more diverse a community is, and the more renewal you have, and the more openness you have. That's not only true for arbitration; it's true for any human body. And you're right to say that we have done a lot. I think I remember once my friend Antonia Stimolica telling me that when she was a court member at the end of the 90s, she was the only woman in the court. When I came in, I think the court membership was 120 members, and there were about 15 women, so less than 10%. Now we will have in the new court that will be elected for the 2021-2024 term, we will have more women than men. So it's a landslide change. And it's not only on the paper. That means that you have an entire new generation of excellent practitioners coming in at the forefront, taking leadership and seeing things with new eyes and with a much more open approach and with a desire not to do things as they've always been done. So yes, you will see absolutely more adaptability and more willingness to accept changes in the future.
Very good. Thank you for that. I'm going to pass, Alexis, to what I call the third of the chapters that I mentioned to you. We've talked about international arbitration in general. We've talked about the ICC. And now let me ask you for some, perhaps some personal reflections. You have, of course, a very distinguished career in the world of arbitration, of course, culminating with your extremely and extraordinary successful presidency at the ICC. So you really have a unique vantage point. As you reflect back on all of your years in arbitration, and you had to give one advice, say, to arbitrators who are, in effect, at the beginning of their careers as arbitrators, do you have any suggestions to them? We begin with that, and then I'm going to ask you about party counsel, and then I'm going to ask you about corporate counsel.
Yeah, I don't like to give advice. I don't.
Lessons learned.
Well, for an arbitrator, let's say it's an advice I would give to myself. Golden rule would be know your case and also understand party counsel. I think it's important for an arbitrator to understand the way counsel behave, why counsel do certain things that may seem at times a bit odd, or if you've been counsel as well, if you've been an advocate as well, you can understand that better. And I think it's important. The understanding, the common language between counsel and arbitrators is a very important thing for the smooth functioning of arbitration. That's why I think, although I think we have to accept that in investment arbitration, this is something that is probably irreversible. But for commercial arbitration, I would not like to see an evolution where there is too much specialization, in the sense that arbitrators will be only arbitrators and counsel will be only counsel, because that can only be a source of misunderstanding between both.
I think you've covered perhaps party counsel as well. Is there anything special that particular advice that you would give to party counsels at the early on in their career of international arbitration?
Well, I remember when I was at the school bar. The story has nothing to do with arbitration, but it's a story that I always remember. And an old, very old advocate in Paris telling me, look, there are 3 golden rules for an advocate. And what are these rules? Rule number 1 is do not believe what your opponent says. And rule number 2 is do not believe what your client says. And rule number 3 is do not believe what you say. And I think that there's a lot of wisdom into this.
Wise advice. Corporate counsel, any thoughts of wisdom for them?
Be involved. Be hands-on the case. Be involved. Arbitrators like to have them participating to hearings, in particular procedural conferences. Arbitration can only benefit and corporate counsel as well, in their active participation in cases.
Wise advice as well. I've lived that, and I can see the benefits of it. What is next for you? I know, of course, that you very much plan to continue as serve as arbitrator. Can you elaborate a little bit? Do you prefer sitting in investor state cases versus commercial cases? How do you plan to mix your activities? I know you, of course, you teach, you write, are active in so many things. Give us an insight into what lies ahead for you.
Yeah, it's perhaps a bit early to tell. What I can say for sure is that I will continue to sit as an arbitrator. I am at the moment working on the creation of a small arbitration boutique. I can provide you with more details at this stage, but it's a nice project. It's a nice startup which keeps me busy at the moment. I will continue to sit as an arbitrator. I do now more investment work than commercial work because I cannot take ICC work until the end of my term. I think this will rebalance. I like both. I like investment cases a lot, but I think that commercial arbitration is also extremely and equally interesting. We are very fortunate to do what we do. Sitting as an arbitrator is not only an honor, it's a privilege, but it's one of the most challenging and intellectually fascinating activities that you can think of. So this is what I will want to continue doing, of course.
Well, you've intrigued me. You mentioned that you are setting up an arbitration boutique. I realize that you might be somewhat limited in what you can share with us, but having at one point in my career founded my own arbitration boutique, I'll ask you: will that be serving both as counsel and as arbitrator, or it will be a boutique focused on your service as arbitrator?
No, I hope both.
Interesting, Alexis. Well, we'll look forward to hearing the news. Well, Alexis, you've been so generous with your time for our listeners. I'll, in effect, hand you the mic and ask: is there anything else you might want to share with our listeners as you reflect this really wonderful point at what I will assure you that many people regard as just a supremely successful presidency at the ICC?
Yes, just perhaps as a final word, and apart from thanking you, it's been a very, very interesting and nice conversation. Perhaps one thought for our friend Emmanuel Gaillard, who, as you know, just passed. It's a tremendous loss for all of us. I knew him well, of course, as you did. He was not only a great advocate, a great arbitrator, but also a fantastic human being. And really, I still can't figure out how this happened. But he will leave a huge loss for all of us. So I wanted to just say a word about this before we close this conversation.
I join you in that, Alexis. Indeed, it has been just leaves a tremendous void, and the thought will be in ways to honor his memory. But, thank you for that, Alexis. And I thank you as well for really this excellent insights that you've shared with us. We, again, congratulate you, Alexis, on your magnificent term as president and wish you the very, very best for the next chapter in your career.
Thank you so much, Jose. And I hope to have an opportunity soon to share a beer with you in person.
You have no idea how much I'm looking forward to that. But wonderful, Alexis. Thank you so much.
Thank you.
Arbitral Insights is a Reed Smith production. Our producer is Ali McCardle. For more information about Reed Smith's global international arbitration practice, email Jose Estigaraga at jia@reedsmith.com. You can find our podcast on Spotify, Apple, Google Play, Stitcher, reedsmith.com, and our social media accounts at Reed Smith LLP on LinkedIn, Facebook, and Twitter. This podcast is provided for educational purposes. It does not constitute legal advice and is not intended to establish an attorney-client relationship, nor is it intended to suggest or establish standards of care applicable to particular lawyers in any given situation. Prior results do not guarantee a similar outcome. All rights reserved.